If you've come up with an invention, especially in software or AI, there's a very natural instinct. File a patent application and then try to get it in front of companies like Google or Microsoft, right? And as a patent attorney, I want to be clear. Filing is absolutely the right move. You've got to protect it. But here's the part most inventors aren't told. Big tech companies are not in the business of buying new ideas or early stage patents. I've been practicing patent law for over 25 years. I've worked with startups, individual inventors, and established companies. I also spent 4 years as in-house senior patent counsel at the Department of Energy's National Renewable Energy Lab in Golden, Colorado, where I worked directly on licensing technologies to startups and small businesses. And I've worked with major universities on both sides of licensing deals, both acquiring and monetizing intellectual property. So I've seen this from multiple angles and what inventors expect and what buyers are actually looking for. It sounds logical. You've created something new, you've protected it legally, and now you want to monetize it. The issue is that patents don't create demand by themselves. From the perspective of a large technology company, an early stage patent application is not yet something they can evaluate in a meaningful way. There's no issued claim scope, there's no clear enforcement position, and often there's not even any demonstrated connection to a real system that they're operating. So, how do these companies actually evaluate opportunities? Well, in general, they're looking for one of three things: a product or technology they can integrate into their existing systems, a strategic gap or a risk they need to address, like an infringement risk, or a validated position that's tied somehow to a real world use. What they're typically not doing is reviewing early stage filings and deciding to acquire them based simply on the idea alone. All right, now this is important. None of that means you shouldn't file a patent application. Filing a provisional patent application and moving toward a full utility application is still a very important step. It establishes priority, it protects your invention and your position in the market, and it gives you the foundation to build value over time. This is also what you'll end up licensing or selling is the patent application rights, not the actual idea. But the key is understanding that filing a patent application alone, that's just the beginning of the process, not the end. So if your goal is to actually get your invention in front of the right people, here's what you should be doing after you file that patent application. One, identify where your invention fits. Be specific. Don't just say it's AI or it's software. That doesn't mean anything. Talk about what layer, what function, what problem it actually solves. You want to be able to clearly connect your invention to real systems that are used by real companies. Second, create a simple technical demonstration or an explanation of your invention. This doesn't need to be a full product. It can be a prototype, a simulation even, or even a well-structured technical walkthrough. The goal here is to show that this idea works and here's how it would be used and useful to your company. 3, map your invention to real-world use cases. This is where most inventors fall short. You need to connect your concept to existing platforms, known architectures, or widely used approaches. That's what makes it relevant to a potential buyer or a licensee. 4, target the right audience inside companies. Large companies don't buy patents because they received a general pitch or an email. Opportunities for selling or licensing your invention usually come from engineering teams, product groups, or strategic initiatives within these companies. So your messaging needs to get in front of and resonate with those audiences. 5, Think in terms of positioning, not just protection. Your patent protects your idea, but your positioning of the product determines whether anyone is even going to care about it. Now, one of the questions I get all the time at this point is, okay, but how do I actually get this in front of the right people inside these companies? And this is where a lot of inventors go wrong. The instinct is to send a general pitch, sometimes even directly to a legal department or a business development group, and hope that that's going to get some traction. In reality, that almost never works. What tends to be far more effective is a much more targeted approach, identifying the right technical or product facing teams and framing your invention in terms that are directly relevant to what they're working on. That's a more nuanced process. How you identify those people, how you structure that outreach, and how you position what you've built. And it's something I'll break down for you in a more detailed, separate video. But the key takeaway here is this: filing your patent application is definitely the right first step. If you don't do that, you won't have anything to license or sell. But just don't expect the patent itself to carry the entire process. It's not going to. You need to build the context around it that makes your invention meaningful to the people you want to reach. Now, if you'd like me to go deeper on how to actually reach the right people inside these companies, who should you contact and how to structure that outreach, just let me know in the comments. And if this was helpful, consider subscribing to my channel. I'll be doing more videos on how to move from filing a patent application to real world value.